The next person that you're going to hear from, welcome back to those that were with us the first 2 years, and welcome to those that are here for the first time. Stick with us if you can. Each Monday night we will get started at 6:30, and hopefully the parking situation will be worked out and everyone can get in fairly smoothly, and we can get things rolling, and we can just make this a great, engaging and educational program for everyone that wants to participate. But the next person you're going to hear from, and did we want to pass on introduce yourself? I'm so sorry.
Okay. Almost from question 559. I'm just here to see if they're going to tell me any secrets.
The next person I'll introduce is actually one of my neighbors in my hallway, and that is Deputy Prosecutor Kavana Tyler, and she will introduce our speakers for tonight. Kavana.
Good evening, everyone. As Andy said, I am a Deputy Prosecutor at the Prosecutor's Office, and I will be introducing our speakers for this evening. Prosecutor Terry Curry and the Grand Jury Investigation Supervisor Tom Gankars will lead our discussion this evening on an inside look at the grand jury. Now, it will share insight into the grand jury process, as well as how the Prosecutor's Office utilizes the grand jury to investigate and prosecute cases. Now, during Prosecutor Curry's 6 years as a Deputy Prosecutor with the MCPO, he was responsible for prosecuting white-collar crime and political corruption, and served as a supervisor for the Grand Jury Division. He has been involved in multiple grand jury investigations since taking office in 2011, including the prosecution of Stacy Sheedy, an attorney and accountant who was sentenced in 2012 for stealing $596,000 from her elderly and disabled clients. Also, the other presenter, Tom Gankars, joined the MCPO in March after 25 years in the FBI. From 2007 to 2011, he served as Assistant Special Agent in charge of the Indianapolis FBI office. He has extensive experience investigating white-collar crime, fraud, and corruption. And now I present to you Prosecutor Terry Curry and Tom Gankars.
And I would add with Annie that welcome everyone, particularly those of you who have been here before. We see a lot of familiar faces who have been at our prior two sessions, and I first of all would promise you that the subsequent sessions over the course of this month will be a lot more interesting than me. I'm told that when we have the CSI function, actually the crime lab van will be here to be able to see that. So we have some interesting topics set up. And just to add to what Annie said in terms of our program and our outreach efforts, I sometimes start to sound like a broken record in that I say over and over and over to neighborhood associations, church groups, everyone that I have the opportunity to talk to, that we can't just count on our police department. We can't just count on the prosecutor's office to address public safety issues. It needs to be a community-wide effort involving the entire public and all of our public safety agencies. And so that's why we do this program, that's why we do other outreach programs, is to get you involved. And as I do every single year when we have this session, is not only come back next year, but bring 2 or 3 of your neighbors next year, because the more that we engage in this sort of collaborative effort, the better we're going to be able to address our public safety issues. So tonight we're going to talk about the grand jury. And first of all, I need to explain that the way we use this terminology sometimes gets confusing in the local state system, and I never really even focused on this until I thought about talking tonight, because in our office, and Tom's going to talk about our grand jury investigators, and Barbara's son, Sergeant Eads, is actually one of our investigators assigned to our office. We use the term all the time about grand jury investigators, but actually those sort of investigations really have nothing to do with the grand jury process itself. And I'm going to explain and try and delineate the two. Because when we talk about grand jury, on the one hand, a grand jury is a body of citizens which considers evidence to determine if charges should be filed against an individual. And I'm going to talk about some of the statutes that apply to the formulation of a grand jury, how the grand jury is how they hear evidence, and how they make a determination whether a charge should be filed. But in most instances, And when a charge is filed by a grand jury, it's called an indictment. Everyone's heard that term, an indictment. So if a person is going to be charged with a crime, they can be charged in the state of Indiana by one of two mechanisms. They can be charged by a grand jury indictment, at which point the grand jury of 6 folks that we're going to talk about determines that there's probable cause to believe that that person has committed a particular crime, and then returns an indictment charging that individual with a particular crime. But in Indiana, in state court, an individual can also be charged by what's called an information. And as probably some of you heard me say before, in Marion County last year we filed approximately 50,000 criminal cases. If we were to file all those cases by presenting the evidence to a grand jury and waiting for a grand jury to return, the whole system would bog down. So when we charge a crime, and I don't know the exact number, but it's easily got to be 99% of the time, we charge crimes by way of an information. And what that means is that the investigating officer, if it's someone from a detective from IMPD who's investigating a burglary, if he or she determines that they have sufficient information to believe that John Doe has committed that crime, they will put together a probable cause affidavit setting forth what they've learned in their investigation. They'll bring that to our office, and our screening department will determine whether in fact we believe there is sufficient probable cause to believe that this individual committed the crime and what that crime is, and we will prepare an information. The information and the probable cause affidavit will be submitted to a judge who will review it and determine and agree or not agree as whether there's probable cause, and if there is probable cause found by the court, that charge will be filed by way of an information. Again, in state court, probably 99% of the cases we file are by way of a probable cause affidavit and a charging information. However, we do present some cases to a grand jury, and so I'm going to talk a little bit about the grand jury. Before I do, the second half of our presentation will refer to what I call loosely the grand jury investigators. And we have 7 police officers currently assigned to our office full-time to investigate white-collar crime and other long-term investigations. And this has been done historically over the years, going back to another lifetime ago when I was a deputy prosecutor, which Kavana referred to, and I was assigned to the grand jury. And again, the terminology gets confusing because that's what we call it. It never occurred to me until I started preparing this that maybe we should call it something else so it wouldn't be so confusing. But we have the investigators, and in most instances, those cases, again, are charged by way of a probable cause affidavit and information. And when we get to the second half of the presentation, we're going to talk about some of those cases, and Tom will talk about how it is that information comes to our office in the first instance, as opposed to going to, for example, IMPD or the state police, how the information gets to us, and how we initiate discrete investigations of political corruption, white-collar crime, and other long-term investigations. So let's talk a little bit about the grand jury itself, how it's formulated, and how they present the evidence. The court calls a grand jury into session at the request of our office. The jurors are impaneled for a grand jury using the procedure for regular juries. And what that means is summons are sent out. How many people have ever been called for jury duty? Okay, virtually everyone, me too. Anyone ever been summoned for jury duty and turns out that they are being summoned for possible seating on a grand jury? Anyone? Okay. Well, those of you who have been called for jury duty, the potential grand jurors are summoned in the same way. They receive the summons, they report to the court, and then those individuals come from the voter polls and BMV records, just like regular jurors. The grand jury itself consists of 6 grand jurors and 1 alternate. And the way those individuals are selected is the same process. Those of you who have been called for jury duty, the same way as you select for jury duty. There's a voir dire process where deputy prosecutors ask questions of the individuals in terms of their willingness and ability to sit, the ability to hear things and make a fair decision on any matters that are presented to them. And then they are selected much like a regular jury. Once the 6 grand jurors and 1 alternate are selected after being called in, the court itself, and we'll get back to the court, which is responsible for monitoring the grand jury from month to month, the court selects one individual as the foreperson and one person as the clerk of that grand jury. The grand jurors must be U.S. citizens, 18 years of age or higher, and Marion County residents. Russ, you can leave now, because grand jury matters are secret. And by statute, no person may, except within the lawful discharge of their duties upon written order of the court, disclose the nature or substance in grand jury testimony or any decision, result, or other matter. Yes, sir. And we'll take questions at the end as well. Yes, sir. Go ahead.
What's a foreperson?
The person who essentially directs the discussion. So if those of you have ever sat on a jury, in a regular jury, once the case is concluded, the jury will then retire to the jury room to deliberate, and the jury then will select among their own members a person who is the foreperson. And all that person is basically in charge to direct the conversation. And
Is the clerk also among those people?
right. And the clerk, in terms of a grand jury, the clerk is essentially someone who will sign off on the return. So the matters heard before a grand jury cannot be revealed by any of the grand jurors. It can't be revealed by the witnesses or anyone else who participates in the process. At the conclusion, we'll get back to the second, what a grand jury will determine if the matter's been presented, and we'll go back to that burglary and John Doe case. If that went to the grand jury would ultimately vote on it and either determine there's a no bill, meaning that they did not find probable cause and no charge, or they would find a true bill, which is an indictment, and therefore a charge. Now, having said all of that, if in the case of the burglary, John Doe was indicted for burglary, then first of all, the indictment itself would become public record. And secondly, once counsel entered an appearance for the defendant, Mr. Doe in that case, they would receive copies of the grand jury testimony and that sort of thing in the course of regular discovery that we would provide to the PD's office in any sort of case. And so ultimately that information is provided for purposes of going forward in the case. But otherwise, anyone who participates in the process is by statute forbidden from disclosing any of the information. We will occasionally present cases to the grand jury, and an example of the sort of case that we will present to a grand jury was the shooting which occurred in Broad Ripple in August. August 2nd, there was a shooting in Broad Ripple where an individual may or may not have been confronted by a number of individuals. It was late in the evening in Broad Ripple, and he fired some shots, and 4 individuals were shot there. And at the time, the suspect said he was being threatened by the individuals, and so there was a pretty significant question, whether the shooting would meet the legal standard of self-defense or not. And that's a perfect example of the sort of case where essentially we feel it's appropriate to present the evidence and then let 6 citizens, the grand jury, make a decision based upon that evidence. Where it's a close call, and essentially it gives our office a trial run to make a determination. Is this case presentable or not presentable? There may very well be instances where individuals are not being cooperative in an investigation, and so that's another example of a case where we might present the case to a grand jury, where we have the ability to subpoena the individual to the grand jury, elicit their testimony, and perhaps then have the ability to make a case that otherwise we couldn't make because of the lack of cooperation. I'm going to talk a little bit about special grand juries in a minute, but another mechanism that is available in the grand jury is to grant individuals immunity for their testimony that otherwise we wouldn't be able to do but for going through the grand jury process, where again, if an individual is not cooperative and we don't think that they're the suspect, we might grant them immunity for their testimony, meaning that they would not be prosecuted for anything they testified to in the course of the grand jury. So these are examples of things we would do in a grand jury. Another mechanism that we have by presenting things to the grand jury is the grand jury has subpoena power. And so, does everyone know what I mean by subpoena? We would get an order from the court for a subpoena for Russ McQuaid's bank records, for example, and gather evidence or information that otherwise might not be available through a normal investigation. So in the instance of the Broad Ripple shooting on August 2nd, the target of that investigation, in other words, the suspect's name was Tristan Creighton. And so the evidence, all the witnesses were summoned in and evidence was presented. I can't talk about what that evidence was, but what the final conclusion of the grand jury after hearing it was, they believed that Mr. Tristan did not act in self-defense and in fact indicted Mr. Tristan on several counts related to criminal recklessness and handgun violations. So in this instance, Mr. Creighton would have received a target subpoena, which we'll talk about, and he was the target or the subject of that particular grand jury investigation. As a target, if the target of any grand jury investigation receives, they will receive what's called a target subpoena, letting them know that they are in fact the subject of that grand jury investigation. And the subpoena must advise him or her that he's the subject of the grand jury investigation, has the right to consult with an attorney and be assisted by an attorney. If he cannot afford an attorney, the court impaneling the grand jury will appoint one